Greetings, a warm greetings to all the participants from Project Complete Lawyer as well as from outside Project Complete Lawyer who have joined all of us to listen to the legal aspects of the Bishop case judgment, which will be analyzed by Advocate Ajit Joy. He has been a resource person for us in Project Complete Lawyer with regard to the criminal jurisdiction of High Court of Kerala. He's an expert in anti-corruption and anti-trafficking laws. He's also a consultant to the Government of India in subjects relating to the United Nations. He has also practiced as an advocate in High Court of Kerala. He is a specialist in arbitration and criminal law and a former IPS officer. It's a pleasure to have you again in another clinical exercise of Project Complete Lawyer with us. So without any delay, I would like to invite Advocate Ajit sir to initiate his presentation, which I am very sure that each of the participants are very much interested in to hear his own perspectives. And I am very sure that it will be invoking certain pertinent questions from the side of the participants. So without any delay, I invite on behalf of Law and Justice Research Foundation and Cochin Institute of International Arbitration, Advocate Ajit Joy to initiate his presentation on the legal analysis of the Bishop case. Sir, the venue is all yours.
Thank you, Sandeep. Let me take this opportunity to thank my dear friend and classmate, Mr. Johnson Gomez, for this invitation, and also to the Law and Justice Research Foundation, Cochin Institute of International Arbitration. Thank you very much. What I will try to do today is to analyze this case in a balanced manner. I have my views on this case, but then I shall try to project some of the points that have come out of this case. And at the same time, I would like to also analyze another very important case, which was decided quite recently, and that was a case decision from Goa. You might all recollect the famous Tehelka case or the state versus Tarun Tejpal. That was also a decision, and both these decisions are quite similar because the court found the accused not guilty and acquitted both of them. And both of these cases relate to a test of the rape laws in India. So I will mostly speak on the Bishop Franco case, but I shall also be bringing in some of the points from the Tarun Tejpal case. So we'll have some joint analysis of these two cases. So I'm now going to minimize my screen and then start reading my presentation. So I hope you can still see me. I'm visible, isn't it?
Pardon, Ajit sir. Another important information I just want to announce. The session will be a presentation by Ajit sir will be for 45 minutes, and the remaining 50 minutes will be spent for question answer session. And just a gentle reminder that there are participants from outside Project Complete Law, and I'm sure that they also want to ask questions. We will try to entertain as many questions as possible. And if the time doesn't permit, we will try to collect all the questions from the participants and email the same to Ajit sir we will be trying to answer all of them with regard to his time. And so
That
back
is,
to
if
you,
I
sir.
know the answer for all of them.
Yeah,
Let us
sure.
try to understand them together, because
Yes,
criminal
yes,
law
yes.
is one area in which you can have different answers for questions. And
Definitely.
for the judge also, it is very convenient. They can find decisions to support their point of view. There are so many decisions of so many kinds of decisions that you can write a decision in any way you want, supported by a lot of authorities. So let us start. And you can please tell me when 45 minutes are
Yeah,
completed.
yes.
Yeah.
Yes, sir. Yes, sir.
Okay,
Yes,
so
sir.
the two cases which I would like to discuss today, mainly the state versus Franco Molecule. This was decided by the Court of Sessions, Kottayam, and the judge was Mr. Gopakumar G, Additional Sessions Judge 1, Kottayam. The decision was very recent on 14th January 2022. And the trial was completed in 59 days. The charges that were framed were under section 376(2)K, 376(2)N, 342, 377, 376C, 354, and 506(2) IPC. The other case is State versus Tarun Tejpal. This was decided on 21st May 2021. The decision was by Ms. Shama M. Joshi, Additional Sessions Judge of Mapusa, Goa. And while the first case, our Kottayam case, was about 250 pages, the Goa court decision was 527 pages long. While starting, I would just like to say that after reading these two cases and maybe other cases related to rape law, one often thinks as to who is on trial. Is it the victim who is on trial, or is it the accused who is on trial? Because we see that in the Bishop Franco case, the accused was cross-examined or was in the witness stand continuously for 10 days. So just imagine the kind of experience that she might have gone through, standing in the witness stand for 10 days, facing all kinds of questions. And that is why the Supreme Court in the state of UP versus Pakku Elias Yunus said that we should not forget that it is the accused who is on trial and not the victim. And on this note, let us see one aspect of both these cases, that there was a person in authority responsible for what happened in both cases. The accused were persons in authority. In the Tarun Tejpal case, Tarun Tejpal was the editor of Tehelka magazine, and the victim was a junior, a very raw journalist who had just joined a few years back in that office of headed by Tarun Tejpal. Tarun Tejpal himself was a very well-known journalist, author, and who had exposed number of corruption cases. So, a prominent journalist. And the other case involves a bishop, and the convent where the victim was working was directly under the bishop of Jalandhar. And therefore, the court found in both the cases that the accused persons were persons in authority. And this is important from the point of view of the criminal law, because when there is a person of authority involved, there can be a case of aggravated rape. So, what was the final finding of the Kottayam court in Bishop Franco's case? So here the court used the Latin maxim, falsus in uno, falsus in omnibus, which means that false in one is false in everything. Falses in uno, falses in omnibus. The maximum, this particular maxim and how far it can be applied in India was considered in Jayashilan versus State of Tamil Nadu, AIR 2009, Supreme Court 1901. So this, in that decision, the maxim falses in uno, falses in omnibus has not received general acceptance, nor has this maxim come to occupy the status of rule of law. It is merely a rule of caution. All that it amounts to is that in such cases, testimony may be disregarded, and not that it must be, that testimony may be disregarded, and not that it must be disregarded. The doctrine merely involves a question of weight of evidence which a court may apply in a given set of circumstances, but it is not what may be called a mandatory rule of evidence. So the judge says that this doctrine is a dangerous one, especially in India, for if a whole body of testimony were to be rejected because witness was evidently speaking an untruth in some aspect. It is to be feared that administration of justice would come to a dead stop or collapse if we accept that maxim. And an attempt has to be made to, as noted above, in terms of felicitous metaphor, separate grain from chaff, or to separate truth from falsehood. Where it is not feasible to separate truth from falsehood because the grain and chaff are inextricably mixed, and in the process of separation, an absolutely new case has to be reconstructed by divorcing essential details presented by the prosecution completely from the context and background against which they are made. The only available course to be made is to discard the evidence in toto. And this is what the learned judge did, and this is what he said that he had to do. So the Kottayam judge said, in the said circumstances, the claim of the victim that she was raped on 13 occasions under duress cannot be taken reliance on the basis of her solitary testimony. There is no consistency in the statement of the victim. After stating the dangerous consequences of accepting falses in uno, falses in omnibus, the judge concludes as follows. As held by the apex court in Jayashilan case, when it is not feasible to separate truth from falsehood, when grain and chaff are inextricably mixed, the only available course is to discard the evidence in toto. In these said circumstances, this court is unable to place reliance on the solitary testimony of PW1. PW1 is the victim, and to hold the accused guilty of the offences charged against him. I accordingly acquit the accused of the offences under sections, all those sections, section so and so, so and so. So that is it, that he was not able to separate the truth from the falsehood. And he could not trust the sole evidence of the victim. So in the course of the judgment, he has found fault with all other witness statements and several other aspects of the investigation, including some documents. And therefore, then finally he said that, can I believe the solitary evidence of the victim? And then he said that because of these reasons, I cannot also consider that what she is saying is the truth. So, similarly, in the Tarun Tejpal case, what was the end result? So in that case, the Goa judge says, upon considering the other evidence on record, the benefit of doubt is given to the accused, as there is no corroborative evidence supporting the allegations made by the prosecutrix. And the deposition of the prosecutrix also shows improvement and material contradictions and omissions and change of versions which does not inspire confidence. Hence, in view of the discussion made here and above, the prosecution has failed to discharge the burden of proving the guilt of the accused beyond reasonable doubt, and I thus answer the points framed at serials number 7A to 7D and 7F in the negative, and therefore Tarun Tejpal was acquitted. There is a question: solitary testimony of a rape victim. So, did both the courts commit a mistake testing the victim from the standard of a sterling witness I believe what both the courts were trying to look at from a witness, the victim who was the witness, was whether she is a sterling witness. Sterling means a gold standard. Whether we should apply the sterling standard is something that we need to think about. The concept of sterling witness was explained in Deepu versus State. This is 2012, 8 SCC 21. This sterling witness should be of a very high quality and caliber, whose version should therefore be unassailable. The court, considering the version of such witnesses, should be in a position to accept it for its face value without any hesitation. To test the quality of such a witness, the status of the witness would be immaterial, and what would be relevant is the truthfulness of the statement made by such a witness. What would be more relevant would be the consistency of the statement right from the starting point till the end, namely at the time when the witness makes the initial statement and ultimately before the court. That means from the police station, first information to the police, until the trial, what she deposes in the court. It should be natural and consistent with the case of the prosecution, qua the accused. There should not be any prevarication in the version of such witness. The witness should be in a position to withstand the cross-examination of any length, and howsoever strenuous it may be, and under no circumstance should give room for any doubt as to the factum of the occurrence, the persons involved, as well as the sequence of it. Applying this very tough standard, I'm doubtful if anybody can stand up and be a sterling witness, even if you know the case really well, or if you have experienced experienced everything. And there are reasons why one can forget. There are reasons why one may not say the whole, may not be able to say, discuss or explain to the court what happened. So, should the court always look for a gold standard, that is a sterling witness? So in appeal, this can be asked whether the court was right in looking for a gold standard. So in another case, in Wahid Khan versus State, 2010, 2 SCC, page 9. Now the question that remains, it was asked, now the question that remains is whether the solitary evidence of PW1 regarding the sexual violence can be taken reliance. It is true that there is nothing wrong in holding a man guilty, relying on the basis of solitary evidence of a victim. Thus, in a case of rape, testimony of a prosecutrix stands at par with that of an injured witness. It is really not necessary to insist for corroboration if the evidence of the prosecutrix inspires confidence and appears to be credible. One more decision is Raja and others versus State of Karnataka. This is 2016, volume 10, SCC 506. While reiterating the evidence of the prosecutrix in cases of rape, molestation, and other physical outrages, it is to be construed to be that of an injured witness, so much so that no corroboration is necessary. Rule that an accused must also be protected against the possibility of false implication. So not only is they say that no corroboration necessary, but court should also see that an accused is not falsely implicated. It was underlined that the testimony of the victim in such cases, though commands great weight, but the same cannot necessarily be universally and mechanically accepted to be free in all circumstances from embellishment and exaggeration. It was ruled that the presumption of absence of consent of the victim, where sexual intercourse by the accused is proved as contemplated in section 114A of the Evidence Act, was extremely restricted in its application compared to the sweep and ambit of presumptions under section 113A and 113B. So 113A presumption is with regard to consent. So there will be a presumption that she has not consented. And section 113A and 113B relate to the presumption in case of dowry death. under the Evidence Act. It was exposited that insofar as allegation of rape is concerned, the evidence of the prosecutrix must be examined as that of an injured witness whose presence at the spot is probable, but it can never be presumed that her statement should always, without exception, be taken as gospel truth. So, applying these standards, the judge, in both the cases, in Tarun Tejpal case and Bishop Franco's case, considered that the witnesses were not good enough. They were not sterling witnesses. They did not inspire confidence. They did not seem to be credible. So this was the conclusion of the judges in both these cases. So now another question. Did the judge look too much for a sterling witness in the victim PW1? Or was the judge justifying in expecting too much from the witness, that is the victim? So PW1 was, as I mentioned, cross-examined for 10 days. PW1 was cross-examined with regard to her failure to disclose about the details of sexual intercourse in her first information statement, that is the statement given to the police. PW1 would explain that her first information statement was not recorded in a free atmosphere. That is her explanation. According to her, statement was recorded in the presence of her companion sisters, and hence she could not reveal the entire episode. According to PW1, she told her spiritual mother, Sister Lizzie, who is PW2, about the sexual abuse either by the end of 2014 or during the beginning of 2015. Now let us look at PW2's evidence, that is the spiritual mother of the victim. PW2's evidence, on December 2014, she spent 2 days at Kuruvalagnada Convent before Christmas. When she saw the new kitchen, she remarked that the work has been well executed. At that time, PW1 disclosed to her that there is a sad episode behind this work. She also told her that the accused used to visit there, that his character is bad, and that he committed sexual violence on her on many occasions. So entries in Exhibit P34, which is the chronicle, it is like a diary of visitors, also supports that PW2 stayed in the convent during that period. The alleged incidents came to the public domain in 2018, after the FIR was registered. In such a scenario, when the victim testifies that she had disclosed the incident to PW2 as early as on December 2014, it goes without saying PW1's relationship with PW2 was so intense and deep. But surprisingly, this disclosure does not find a place in Exhibit P1 FIS, which means that in the first information statement given by the victim to the police, she did not disclose that the information about the rape was given by her first to her spiritual mother, that is PW2. The disclosure made by PW2 does not find place in Exhibit P19, which is the Section 164 statement of the victim. That means the second statement given by the victim was a 164 statement before a magistrate. In that also, she did not disclose that the first person she told this about this event was PW2. Normally, a survivor would not forget. This is what the judge is writing. Normally, a survivor would not forget to reveal about her first disclosure in her subsequent statements. And therefore, the judge says that the defense has a case that PW2, that is the spiritual mother, was a planted witness to supply corroboration to the version of PW1. To corroborate what she wanted to say, they brought in PW2. That is what the defense says. Now let us look at the statements of some other sisters. PW3, Sister Nina Rose. PW4, Sister Anupama. And see how the judge brings out the contradiction in their statement. So the victim and these sisters, they went for a retreat to Attapadi in September 2016. While there, the sisters came to the victim's room and asked her why she was looking so dull. PW1 told them that the accused had raped her multiple times since 2014, that he committed unnatural sexual abuse on her, that she could not tell anyone, and that she could not resist the accused from visiting the convent. So this was disclosed to PW3 and PW4 in September 2016. Now look at the contradiction. In the section 164 statement, that is the one made before the magistrate, PW1 says she did not disclose to PW3 and PW4 even during December 2016 that she had slept with the accused. The testimony of PW1, PW3, and PW4 therefore cannot be relied upon, because when they went to Attapadi, during that time, the victim says that she had not disclosed anything. PW1 had given a voluminous Section 164 statement to the magistrate, which runs to more than 100 pages. There is no reference about attending any retreat at Attapadi, or about the unusual long confession which she made before the priest, or about the disclosure to PW3 and 4, which questions the genuinity of the versions of PWs 1, 3, and 4 that PW1 had disclosed to them about the rape and sexual violence committed on her by the accused as early as on September 2016. So my question here is, one, in the appeal, how is this going to be explained? And number two, is it such a big flaw as to vitiate this case that, okay, there is a contradiction? You tell you say that you had disclosed to 2 other sisters on such and such date, but you did not disclose the same in the FIS. So how much credibility should the judge give to that? And should that be the basis alone to dismiss the entire evidence of these other sisters? Now let us look at the Tarun Tejpal case. So in this, the judge says that the IO has not conducted any investigation or questioned the prosecutrix on why she dropped all mention of Nikhil Agrawal from her complaint of 18/11/2013. Though the prosecutrix admitted that in her email of 16/11/13, she had stated that Nikhil Agrawal was the first person she met and spoke to in the minutes after the alleged incident on 7/11/2013. In both these, please see that the court is trying to ask that the first person you met and first person you disclosed to, why have you not mentioned them in either your FIS or in your statement before the magistrate? So I think the court is putting extraordinary amount of importance to the first person that the incident is disclosed to. Okay, in the course of the trial, there were some testimonies that did not help the prosecution. PW1 says that sexual assault committed by the accused was disclosed to PW17, who is Bishop Sebastian, and PW18, Mar George Alanjeri, both Cardinal Mar George Alanjeri. The evidence of PW13, Father Varghese alias Dai, and PW14, Father Joseph Tadappil, also will not prove that the victim complained to them about the sexual abuse. So when they came to the witness stand, none of them said that the matter of the sexual abuse was disclosed to them. So none of these witnesses were declared hostile and cross-examined by the prosecution. The prosecution cannot simply discard their evidence on the premise that they were won over by the defense. Their evidence are binding on the prosecution, and the defense can place reliance on their evidence. So, based on certain decisions, the judge held that that disclosure witness which did not help the prosecution will go against the prosecution. There were certain lacunas in the prosecution. The defense contends that there is an additional statement of the victim, which was taken on 30/6/2018, that is 2 days after the FIRs was recorded, but subsequently after the arrest of the accused. It is also contended that there was no reference about the disclosure made to PW2 in any of the statements made by the victim prior to the arrest, and that hence an antedated statement of the victim was brought into picture to add credibility to her version. So the defense says that though the statement date is mentioned to be 30/6/2018, this was taken much later, and this additional statement was made to cover up several loopholes, like not mentioning PW2. So defense also places reliance on Exhibit D42, which is a report submitted by the investigating officer before the Honorable High Court of Kerala to buttress its point. There is no mention of Exhibit D in Exhibit D42 statement that additional statement of victim was taken on 30/6/2018. So see, there is a material contradiction in a document submitted at a particular time. So there is every reason to believe that the additional statement was taken much after the date which is actually recorded. Now there is another very important question in this. Did the judge in the Bishop Franco's case lose his way by looking for penile penetration? We all know that the amended law on rape does not require penile penetration. So let us look at the medical evidence. PW1 was questioned with respect to the history disclosed to the doctor. She admitted that the entire matters within her knowledge were disclosed to the doctor. According to her, she had full trust in the doctor and that the history was disclosed to the doctor in a free atmosphere. As per the history narrated to the doctor, she was subjected to assault, including touching of private parts, inserting his fingers in the victim's vagina, and forces her to touch his private parts and ejaculate in front of her. Victim explained that the history was with respect to the incidents which occurred on 5/5/2014. There is no allegation of any penile penetration in Exhibit P1, first information statement. This is the analysis of the judge. As regards the sexual violence committed on 6/5/2014, the victim's version Exhibit P1 FIS is that accused removed her entire dress and repeated the acts which were done on 5/5/2014. There is no allegation of penile penetration anywhere. In Exhibit P1 FIS, in her cross-examination, PW1 was asked about this anomaly. Her explanation is that P1 first information statement was not taken in a free atmosphere. She further states that she had no trust in the woman police officer who recorded her statement. It is argued from the side of the prosecution that 2 days later, on 30th itself, victim's additional statement was recorded wherein the entire incidents were narrated. Defense has got a definite case that the statement is an antedated statement and that it was actually recorded sometime in September, which we have just discussed about. So the judge says one may think that non-disclosure about the penile penetration was an innocent omission on the part of the victim. But the evidence of PW21 and Exhibit P55 medical report and Exhibit X1A copy of the report kept in the medical examination register proves that the victim has failed to reveal about penile penetration to the doctor as well. PW21, who was working as additional professor in obstetrics and gynecology at Medical College Hospital, Cochin, records history of multiple sexual assault by Bishop Franco, who was occasional visitor to the convent home, history of assault multiple times, 13 times, that is in a 4-year period, assault including touching of private parts, inserting his fingers in victim's vagina, forces to touch private parts, etc. Though it is revealed to the doctor that there were 13 episodes of sexual assault, there is no mention of penile penetration. Some portion of the history narrated by the victim was found struck off in Exhibit P55 medical report. P21, that is, a doctor was asked about these corrections in the medical report. She admitted that it was she who struck off the entry in page number 3 of Exhibit P55. She also deposed that PW1 had narrated to her that the sexual assault was repeated for 4 years. After the completion of medical evidence of PW21, the defense summoned the carbon copy of the medical examination register from the Medical College Cochin. The document was subsequently marked PW39. Surprisingly, no portion of the history written by the doctor has been struck off from the carbon copy, from which it is obvious that portion was struck off at a later point of time. So the original one reads at the end of that report, which is struck off, is that no history of penetrative sex according to victim. Last episode 1 year back. So this was struck off in the report, in the version of the report submitted to the court. And so this is something that the court disbelieved. It was not very satisfied about the medical report, and at the same time, it was now established that there was no history of penetrative sex according to the victim. So the question that we need to ask is, the penile penetration is not necessary for rape. Just by the insertion of finger is enough to constitute rape as per the definition in 375. We may also just go through the definition of rape in 375. And I feel that even with this version of the doctor and the medical, the questioning on medical grounds was sufficient to prove the offense. So 375 rape, a man is said to commit rape if he penetrates his penis to any extent into the vagina, mouth, urethra, or anus of a woman, or makes her to do so with him or any other person. And B inserts to any extent any object or part of the body, not being the penis, into the vagina, urethra, or anus of a woman, or makes her to do so with him or any other person. And then there is C and D. So I think this is already covered from the statement of what the we can argue this way, that from the statement of the victim and from what she disclosed to the doctor, the offense could be deduced by the judge that the offense is already made out. Then comes a very important point, and this is on the question of delay in registration of FIR. This is one question that repeatedly comes up in such cases. PW1 initially preferred Exhibit P20 complaint, that is the FIRs. P20 complaint is a complaint given to the district police chief. This was on 27/6/2018. The said complaint was forwarded to the SHO Kurvalangad police station for further action. On 28/6/2018, FIR was registered. So this is in June 2018. Registration of FIR is in June 2018. So in between, the victim has made complaints to the church authorities, and she has also sent a complaint to the representative of the Pope in India. So the first incident of rape, according to the victim, was on 5/5/2014. So you can see that from the first date till the registration of FIR, there is more than 4 years gap. So 5/5/2014 is the first incident. Registration of FIR is in 2018 June. And then there are 13 incidents. There are 3 incidents in 2014. There are 7 incidents in 2015. And there are 3 incidents in 2016. The last incident of the sexual abuse was on 23/9/2016. So from the last day also till the registration of FIR, we see that there is a gap of at least 20 months, nearly a little less than 22 months, less than 2 years. So what is the impact of delay on the prosecution? This is also a question that was considered by the court in Cochin. So the court discussed the decision in Dildar Singh versus State of Punjab, 2006, Volume 10, SEC 531. Delay as such will not impact the merits of the prosecution case. The relevant portion of Dildar Singh says like this. This court has observed in several decisions that the courts cannot overlook the fact that in sexual offences, delay in lodging of FIR can be due to a variety of reasons, particularly the reluctance of the prosecutrix or of family members to go to the police station and complain about the incident which concerns the reputation of the prosecutrix and the honor of her family. A girl in a tradition-bound, non-permissive society would be extremely reluctant even to admit that any incident had occurred. Her not informing anyone about the incident in these circumstances cannot detract from her reliability. Thus, delay in lodging the first information report cannot be used as a ritualistic formula for doubting the prosecution case and discarding the same on the ground of delay in lodging the first information report. So, it's not a ritualistic formula for doubting the prosecution. Delay has the effect of putting the court on guard to search if any explanation has been offered for the delay and if offered, whether it is satisfactory. In the state of UP versus Manoj Kumar Pandey, this is 2009, Volume 1, SEC 72. The Honorable Apex Court stressed that the normal rule regarding the duty of the prosecution to explain the delay in lodging FIR and the lack of prejudice and or prejudice caused because of such delayed lodging of FIR does not per se apply to cases of rape. And this has been the consistent view of this court. So there is one more decision, but based on all this, it says that if delay is explained, it will not be fatal for a case involving a sexual abuse. Now, there are several areas that are covered, that are discussed, but one last point that I want to discuss now, and we can have a discussion after that, is on the scene of crime, or the importance of the scene mahasar. So let us discuss a bit on the proof of the place of occurrence. So the Kottayam court says that all the 13 incidents have occurred in guest room number 20, and that which was used by the bishop. So all the 13 incidents occurred in just one place, which is room number 20 in the convent. Prosecution witness, PW1's evidence is that she was also staying in the same floor. Prosecution relies on the evidence of PW 38 and 39, the IO, and the evidence of PW 25, the village officer, and PW 26, the Panchayat Assistant Secretary, to support the version of PW 1 regarding the place of occurrence. PW 25 village officer prepared Exhibit P62 scene plan on the basis of the scene mahasar. He deposed that the guest room where the incident occurred is on the first floor of the building, and it is inside first floor of the convent building. Though a detailed narration of room number 20 is made in exhibits P39 and P40 scene mahasar, there is no mention regarding the location of the room used by PW1. The evidence of PW8 was present, who was present at the convent during the first 12 incidents, is that she does not know who was using the room opposite to room number 20. The evidence of PW19 is that 3 or 4 inmates were residing at the old age home. According to her, the inmates were staying at the ground floor, but she does not know who all were staying at the first floor. She admits that there is a ladies' hostel on the second floor. It is also admitted that hostlers who have to pass through the front of the guest room to reach downstairs. The investigating officer claims that no one was staying in the ladies' hostel, but he admits that the registers of the old age home and hostel were not checked. He admits that it is mentioned in Exhibit P40 scene mahasar that the old age home is functioning on the ground floor of the first floor. Thus, it is clear that no proper investigation was made in this regard. So please remember, a clear description of the place of occurrence and the way it is recorded and the witnesses who speak about it should inspire confidence in the court. In the scene Mahasar in Tehelka case, also this was the issue. And in the Tehelka case, the place of occurrence, there were 2 days on which it is said that Tarun Tejpal had sexually abused the victim, and that was both incidents took place inside the lift of the hotel in Goa. The IO, and this is a decision from the Goa case. The IO PW70 during the scene of offense, Panchanama, which is like the Mahasar, on 28/11/13 did not ask the prosecutrix to show which button was pressed by the accused on the lift panel to keep the lift in circuit during the incident of 7/11/2013. This is not mere detail, but the heart of the prosecution case, since it is the categorical case of the prosecutrix that the lift door did not open even once during the 2 minutes of the alleged incident, as the accused pressed a button on the lift panel to keep it in circuit. So that button was not, they were not able to explain which one was it. Was it the emergency button or some other button? The IO did not verify during the scene of offense whether the lift could be kept stationary by pressing a button on the lift panel. Till date, IO has not produced any empirical evidence to show that a button on the lift panel can keep the doors closed when the lift is stationary between floors. The IO has not conducted any investigation to verify and ask the prosecutrix the very basic question of where inside the lift the prosecutrix was standing during the sexual assault of 7/11/2013 and 8/11/2013 during the scene of offense Panchanama. So there were flaws in the investigation in the Kottayam case as well. Like during the deposition in court, the victim said of an incident that occurred on 15/1/2015. That sexual assault took place on 15/1/2015. But there was nothing in either the investigation report or any explanation from the IO as to why this particular date incident of 15/1/2015 was not in the case diary or any other documents. The defense also had pointed out one important lacuna, which was that the mobile phone used by the victim, mobile phone used by PW16 and CW17, and the laptop used by PW1 were purposefully kept out of the court. They were not produced. There were no examination of these two evidence. One more important aspect the court considered, both in the Kottayam case and Goa case, is the post-incident communication between the accused and the victim. And so they found that the way in which they have communicated after the incident also raises certain doubts as to the veracity of the incident that was reported. So let me now stop here, and then we have covered a lot of area, and so we can invite questions that you may have. So what we have seen is, I cannot blame the judges for what they have done.
So, may I ask a question? So, though Bishop Franco is acquitted for the time being, it is common belief that he is liable to be punished, and there is a finding on the part of the media and the legal sector that the prosecution failed to submit sufficient evidences. Is it correct? And the prosecution is going for an appeal. What is your observation about the future of the case?
Well, as I was discussing, there are different ways from the point of view of the judge to arrive at a conclusion saying that I cannot separate the truth from the falsehood, and therefore I discard the entire set of evidence. Is that justifiable? That is one question. Second, in order to prove the case, I believe that the evidence collected by the prosecution was sufficient. This is something that the prosecution will bring out in their appeal. From the side of the defense, they will say that, see, what the judge has held is perfectly right, because there are so many contradictions in the FIRs, contradiction in the 164 statement, in the subsequent statement. So they will say that the medical evidence that shows that they have tried to only project that part which is good for the prosecution. So they would say that even from the viewpoint of a fair investigation, that did not take place, because see, whatever was inconvenient, like the laptop or the phone, you have not produced. The medical evidence you were not able to explain. So these are some of the facts that the defense has in their support. So how will the court decide? That we'll have to see. But it is interesting that both these cases will come up for appeal in appeal, and from the point of view of the statements of the victims, if we I believe that there is sufficient disclosure in the statement of the victims, and perhaps sufficient for the court to rely on them.
Clear, sir, clear, very clear. Okay, sure.
Dear participants, kindly introduce yourself first before asking the question. The floor is also open for more questions from the participants. So, is there any other questions?
Excuse me.
Yes.
Can I speak in Malayalam?
Yes,
Sure.
Okay. ഇവിടെ
Please
ഇപ്പോ ഓക്കെ, എൻ്റെ പേര് നാൻസി എന്നാണ്. ഇവിടെ ഇപ്പോൾ കോടതി പറഞ്ഞിരിക്കുന്നത്, ഇപ്പോൾ മെഡിക്കലായിട്ടുള്ള തെളിവുകൾ ഹാജരാക്കിയിട്ടുണ്ടല്ലോ. ഈ കേസിൽ മെഡിക്കലായിട്ടുള്ള തെളിവുകൾ ഹാജരാക്കിയിട്ടുണ്ട്. അതുപോലെ തന്നെ ഇപ്പോൾ ഒത്തിരി കാലം കഴിഞ്ഞിട്ടാണ് ഈ കേസ് ഫയൽ ചെയ്യപ്പെടുന്നത്. അപ്പോ അതിൻ്റെതായിട്ടുള്ള എന്താണ് ഡേറ്റിലും ഒക്കെ ഉള്ള വ്യത്യാസം, സാക്ഷികളുടെ മൊഴിയിൽ ഡേറ്റിൽ വ്യത്യാസം വരും. എന്നിട്ടും കോടതി അതിന്റെ ഒരു ആ റീസൺ ഒന്നും കൂടെ പറയാമോ? എന്തുകൊണ്ടാണ് തള്ളിയെന്നുള്ള റീസൺ ഒന്നും കൂടെ പറയാമോ?
നേരത്തെ പറഞ്ഞ പോലെ ഈ മെഡിക്കൽ എവിഡൻസിൽ ഡോക്ടർ അതിനെ തിരുത്തിയിട്ടുണ്ട്, മെഡിക്കൽ എവിഡൻസ്. സോ ഫസ്റ്റ് കൊടുത്ത മെഡിക്കൽ എവിഡൻസിൽ പ്രോസിക്യൂട്രിക്സ് പറയുന്നത് ദർ ഈസ് നോ പീനൈൽ പെനിട്രേഷൻ എന്നാണ്. അത് സ്ട്രൈക്ക് ഓഫ് ചെയ്തിട്ടുണ്ട്. പിന്നെ വിറ്റ്നസ് സ്റ്റേറ്റ്മെന്റ്സ്, ലൈക്ക് വി എക്സ്പ്ലെയിൻഡ് ഏർലിയർ, first she says that disclosed about the incident to PW2, അതായത് സ്പിരിച്വൽ മദർ, സ്പിരിച്വൽ സിസ്റ്ററിനോട് ആദ്യം പറഞ്ഞു അത്. പക്ഷെ ആ ഒരു ഫാക്ട് is not explained in the FIR or in her 164 statement. So there are many contradictions, that is what the judge is saying, in the statement of the victim. Then there is also a counter story that has been brought out by the defense about maybe some other affair. So it was not easy for the judge, I am sure, both in Teelka case and in Bishop Franco's case. And in both the cases, the judges have worked very hard to bring in all the evidence, analyze it, and finally arrive at a conclusion. And I still feel that maybe our justice system is one that gives benefit of doubt to the accused.
All right,
Okay.
I have a question.
Yes, Mohan.
See, you told that the doctor's report was, interfered with or fabricated. I mean, there has been some interpolation by the police, right?
Yeah.
So, is it not the police have not? Don't you think that the police have tampered the evidence? Investigation should be fair and impartial. That should be to the accused also. And once they tend to interfere with the evidence, whatever they collect, is it not an attempt in trying to frame a person, or probably interfering with the course of justice? What is your opinion on that?
Yes, that's a good question, and this is perhaps one of the main reasons why the case ended in acquittal as well. Because I also strongly believe that the investigation and the prosecution as well were trying to close all loopholes in the case, in the investigation of the case, which is not needed. Many loopholes need not be, all loopholes cannot be closed and need not be closed. Let there be doubts. Let us say, for instance, 2 plus 2 plus dash is equal to 6. Now, if you leave that, the third blank, it is okay. The court can assume that it is 2 plus 2 plus 2. But if you investigate and bring in 2 plus 2 plus 4 is equal to 6, it will never work out. The calculation doesn't work out. So no need to fill that gap with something which is not in existence. That is what happened in this case. Yeah. So I think that was one of the major reasons why the judge did not believe what happened.
I also feel that the court did not say that Bishop Franco is a saint. Bishop Franco was just given the benefit of doubt, or probably
Absolutely.
the court
Yes.
has not given him a absolute clean chit in that.
No.
Do you think so?
No, they not given a clean chit. It was just that the evidence was not forthcoming against him, was not good enough to convict him.
The prosecution.
In fact, there is one aspect of the judgment discusses on the bad character of the accused. So the reports against the accused is also discussed in the judgment.
As the media says, the court has not given him any saintly status or anything like that.
No, not given a clean chit at all.
Just that the story was not inspiring enough to convict Bishop Franco.
Absolutely, that's true.
That's all.
Mohan Jacob, thank you for the question. Again, gentle reminder to the participants, before raising the question, kindly introduce yourself for the record. There is a question from, yes, please.
Good evening, sir. My name is Anandu. Sir, ഒരു ഡൗട്ട് എന്ന് പറയുന്നത് സാറേ, ഈ നമ്മുടെ ജഡ്ജ്മെന്റിൽ പാരഗ്രാഫ് 88 PW1 ടെസ്റ്റിഫൈ ചെയ്യുന്നുണ്ട്, സെക്ഷലി കളേർഡ് റിമാർക്ക് ആയിട്ടുള്ള മെസ്സേജസ് ഈ അക്യൂസ്ഡ് അയച്ചിട്ടുണ്ട് എന്നുള്ള കാര്യം. സോ അത് പ്രോസിക്യൂഷന് പ്രൊഡ്യൂസ് ചെയ്യാനും പറ്റിയിട്ടില്ല. അത് പറയുന്നു മാത്രമേ ഉള്ളൂ, ഒരു ഡോക്യുമെന്റ് അത് കോടതിയിൽ പ്രൊഡ്യൂസ് ചെയ്തിട്ടില്ല. അപ്പൊ അത് എത്രത്തോളം ഇതിനെ നമ്മുടെ ഈ കേസ് വീക്ക് ആവാൻ എത്രത്തോളം അത് ഇത് ചെയ്തു എന്നുള്ള കാര്യമാണ് സാർ.
അത് മറ്റേ മൊബൈൽ ഫോൺ പ്രൊഡ്യൂസ് ചെയ്തിട്ടില്ല. അത് എല്ലാം എവിഡൻസും കവർ ചെയ്യണമെന്നുമില്ല. ഉള്ള എവിഡൻസ് വെച്ചിട്ട് കൺവിക്ഷൻ വാസ് പോസിബിൾ.
അല്ല, ആ ഒരു മീൻസ് ആ ഒരു പാരഗ്രാഫില് പറയുന്ന കാര്യങ്ങൾ ശരിക്കും പറഞ്ഞാല് അത് ശരിക്കും അവരുടെ ആ ഒരു കോൺവെർസേഷൻ, ഐ മീൻ ഈ ഒരു അഫയറിനെ കുറിച്ചും ബാക്കിയുള്ള കാര്യങ്ങളും ഒക്കെ ആ ഒരു ഫോൺ സംഭാഷണത്തിലാണ് കൂടുതൽ നടന്നതെന്ന് ഞാൻ മനസ്സിലാക്കുന്നു സാർ. അപ്പൊ അത് പ്രൊഡ്യൂസ് ചെയ്യാത്തത് നമ്മൾ ആ ഒരു പ്രോസിക്യൂഷനെ വീക്ക് ആവാൻ അതൊരു കാരണമായോ എന്നാണ്.
ഇതിനകത്ത് വേറെയും പറയുന്നുണ്ട് that the character of the witness did not be brought into question at all. ഇങ്ങനത്തെ കേസസിൽ ക്യാരക്ടർ ഇസ് നോട്ട് റിലവൻറ്റ്.
ഓക്കെ, താങ്ക് യു സർ.
Thank you, Ajit. It was a wonderful presentation. I know that you have taken a lot of pain in making this presentation, and happy to see Mohan also joining. And we were all classmates in the Government Law College, Trivandrum. I hope that Mohan will be joining us in some other sessions very soon. I express my sincere thanks. It's not official, but it is only personal. If anybody has any further questions, you may ask. Thank you.
സർ എൻ്റെ പേര് ഷെഹനാസ്. സർ, വിധി വന്നതിന് ശേഷം ഡിഫൻസ് ലോയർ മീഡിയ പേഴ്സൺ ആണ് ഇതിൽ ഒരു പ്രധാന ഹെൽപ്പ് ചെയ്തതെന്ന് പറഞ്ഞില്ലേ? അഭിലാഷ് മോഹനെ കുറിച്ച്, ആ ഇന്റർവ്യൂവിനെ കുറിച്ച് പറഞ്ഞില്ലായിരുന്നു? അതെങ്ങനെയാണ് ഈ കേസിനെ അഫക്ട് ചെയ്തത്?
ആ ഒരു ആസ്പെക്ട് എനിക്ക് അത്രയും ക്ലിയർ ആയിട്ട് അറിയത്തില്ല. ഞാനത് സോറി, ഐ ഡോണ്ട് നോ ദാറ്റ് എങ്ങനെ അഫക്ട് ചെയ്തോ.
അഭിലാഷ് മോഹൻ അനുപമയായിട്ട് ചെയ്തിട്ടുള്ള ഒരു ഇന്റർവ്യൂ, അത് ഇതിൽ ഒരുപാട് ഹെൽപ്ഫുൾ
അതെ,
ആയിരുന്നു.
അതിന് ഹെൽപ്ഫുൾ എന്ത് മാത്രമായിരുന്നു എനിക്ക് അറിയത്തില്ല. ആ ഒരു ഇന്റർവ്യൂവിൽ കോൺട്രഡിക്ഷൻ ഉണ്ട്. ഇന്റർവ്യൂവിൽ പറഞ്ഞ കാര്യങ്ങൾ പിന്നെ അത് മാച്ച് ചെയ്തിട്ടില്ല ഫസ്റ്റ് ഇൻഫർമേഷൻ സ്റ്റേറ്റ്മെന്റ് ഒക്കെ ആയിട്ട്. പക്ഷെ അത് അത്രയും ഒരു യൂസ്ഫുൾ ആണോ എന്ന് എനിക്ക് അറിയത്തില്ല. അതൊരു ഒരു പെരിഫറിയിലുള്ള ഒരു ഇന്റർവ്യൂ ആണ്. അത് കോർ ഓഫ് ദി ഒഫൻസ് പ്രൂവ് ചെയ്യാനോ പ്രൂവ് ചെയ്യാതിരിക്കാനോ അത് അത്രയും ഹെൽപ്ഫുൾ ആണെന്ന് തോന്നുന്നില്ല.
സർ, നോർമലി അങ്ങനെയുള്ള ഇന്റർവ്യൂസ് ഇത് കണക്കിലെടുക്കുവോ? പബ്ലിക്കിലോ ഇങ്ങനെ ഇന്റർവ്യൂസ് ഒക്കെ പറയുമ്പോൾ അവരെല്ലാം റിവീൽ ചെയ്യണമെന്നില്ലല്ലോ.
അതെ, ശരിയാണ്. റിവീൽ ചെയ്യണമെന്നില്ല. പക്ഷെ ദേ വിൽ ടേക്ക് ദാറ്റ് ഇൻ ടു അക്കൗണ്ട്. അത് ഇതിനകത്ത് ദാറ്റ് ഹാസ് എ ബെയറിംഗ് ഓൺ ദ കേസ്. അത് വിൽ ബി സബ്ജക്ട് ടു ക്രോസ് എക്സാമിനേഷൻ.
ഓക്കെ സർ.
Sir, my name is Kuriyachan, sir.
Yes, yes.
Sir, ആ ഇന്റർവ്യൂവിന്റെ കാര്യം പറഞ്ഞപ്പോൾ അതിൽ PW3 ആ ഇന്റർവ്യൂവിൽ പറയുന്നുണ്ട് അവർ കോംപ്രമൈസിന് തയ്യാറായിരുന്നു, അവരുടെ ഡിമാൻഡ്സ് അംഗീകരിച്ചിരുന്നിരുന്നെങ്കിൽ കോംപ്രമൈസിന് തയ്യാറായിരുന്നു എന്നൊരു എലമെന്റ് അവർ പറയുന്നുണ്ട്. അപ്പൊ അത് കോർട്ട് ജഡ്ജ്മെന്റിൽ നോട്ട് ചെയ്തിട്ടുണ്ടായിരുന്നു.
അതെ 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 അത് ശരിയാ അത് ശരിയാ അത് ശരിയാ.
അതെ അതെ. അപ്പൊ എനിക്ക് ചോദിക്കാനുള്ളത് സർ, വിക്ടിമിന്റെ ക്യാരക്ടർ ഒരു ക്രിമിനൽ കേസിൽ എന്തുമാത്രം റെലവെന്റ് ആണ് സർ? കാര്യം കോടതി ഈ ജഡ്ജ്മെന്റിൽ ഒരുപാട് കൺക്ലൂഷൻസ് വിക്ടിമിന്റെ ക്യാരക്ടറിനെ പറ്റി പറഞ്ഞിട്ടുണ്ടായിരുന്നു. ഒരു ഇല്ലിസിറ്റ് റിലേഷൻഷിപ്പിന്റെ കാര്യം പറയുന്നുണ്ടായിരുന്നു.
അങ്ങനത്തെ ഒരു ഡിസ്കഷൻ ഉണ്ടായിരുന്നു. അല്ലെങ്കിൽ ഈ കേസിലോ ഒരു അത് പാടില്ല. മറ്റേ ഈ തഹൽക കേസിൽ സ്പെസിഫിക് ആയിട്ട് they have excluded lot of evidence, WhatsApp chats, since it reflects on the character of the victim. അതെല്ലാം എക്സ്ക്ലൂഡ് ചെയ്തു.
Okay sir, thank you sir.
And ഇങ്ങനത്തെ ഒരു കേസിൽ even if there was some sexual before or after the incident, it has no relevance.
സർ, പക്ഷേ ഇൻസിഡന്റ് കഴിഞ്ഞുള്ള വിക്ടിമും അക്യൂസ്ഡും ആയിട്ടുള്ള കമ്മ്യൂണിക്കേഷൻ അതിലൊരു റിലവന്റ് ആയിട്ടുള്ള പോർഷൻ ആയിട്ട് പറയുന്നു. അപ്പൊ അത് വിക്ടിമിന്റെ ക്യാരക്ടറുമായിട്ട് ബന്ധപ്പെട്ട വരത്തില്ലേ സാർ?
ഇല്ല, അത് വിക്ടിമിന്റെ ക്യാരക്ടറായിട്ട് വരത്തില്ല. ഇഫ് ഇറ്റ് ഹാസ് എനി റിലേഷൻ ടു ദി ഇൻസിഡന്റ്, ദ മെയിൻ ഇൻസിഡന്റ്, അത് മാത്രമേ ഉള്ളൂ. എന്നാൽ മാത്രമേ ഉള്ളൂ അത് റിലവന്റ് ആയിട്ട് വരത്തുള്ളൂ.
ഓക്കെ സർ.
Ajit, I am Biju. Can you speak?
No, I
Biju?
think
Another classmate.
please,
huh?
please, please, go on, go on, please.
Throughout the meeting, I was there. Ajit, my doubt is, I'm not at all acquainted with criminal side. So my doubt is actually in this judgment, the judge says that this he was actually sidelining the testimony of PW, if I remember correctly, 3 and 4, saying that judge victim സ്പെസിഫിക് ആയിട്ട് പറയുന്നില്ല, അതായത് ഈ റേപ്പ് അല്ലെങ്കിൽ ദ ആക്ഷൻ വിച്ച് അമൗണ്ട്സ് ടു റേപ്പ് എന്ന് പറയുന്നില്ല. എനിക്ക് കൂടെ കിടക്കേണ്ടി വരും, ബിഷപ്പ് വരാൻ ചാൻസ് ഉണ്ട്, ബിഷപ്പ് വന്നാൽ എനിക്ക് കൂടെ കിടക്കേണ്ടി വരും. ഇങ്ങനെ ഇത്രയും മെർക്കൂറിയൽ പ്രൊസഷനിൽ പോയി ഒരു ജിക്സോ പസുകൾ ഇത് ചെയ്യുന്ന കണക്ക് ഉള്ള ഒരു ഇതാണോ കോടതി ഈ റേപ്പ് കേസസില് സുപ്രീം കോടതി ജഡ്ജ്മെന്റിന്റെ എന്റെ ഒരു ഓർമ്മ ശരിയാണെങ്കിൽ 1990 ഫാത്തിമ ബീബിയുടെയൊക്കെ ജഡ്ജ്മെന്റ് ഉണ്ട്, കേവൽ ചന്ദ് ജെയിൻ എന്നൊക്കെ പറഞ്ഞിട്ടൊരു കേസിൽ ഇത്രയും മെർക്കൂറിയൽ പ്രൊസഷനിൽ പോകാൻ പറ്റുമോ? അതായത് ഒരു എസ്പെഷ്യലി ഈ ക്യാരക്ടർ ഓഫ് ദ ഒഫൻസ് നമ്മൾ കൺസിഡർ ചെയ്യുമ്പോൾ അങ്ങനെ പറ്റുമോ? അതൊരു ക്വസ്റ്റ്യൻ. പിന്നെ രണ്ടാമത്തെ കാര്യം, അതായത് ഇത് ഒരു സൈഡ്, ഞാൻ വിക്ടിമിന്റെ സൈഡിൽ നിന്നുള്ള ഒരു ക്വസ്റ്റ്യൻ ആണ് ജിത്ത്. പിന്നെ രണ്ടാമത്തെ ചോദ്യം, ഈ പ്രോസിക്യൂഷന്റെ സൈഡിൽ നിന്ന് ഇതില്, അതായത് ഫോർ എക്സാമ്പിൾ ഒന്ന് ഇലക്ട്രോണിക് എവിഡൻസസ് അഡ്മിറ്റ് ചെയ്യുന്നതിൽ ഒരു ഒമിഷൻ പറ്റിയിട്ടുണ്ടെന്ന് പറയുന്നു. പിന്നെ രണ്ടാമത്തെ കാര്യം, പലപ്പോഴും അതായത് ഇവര് വളരെ ഗ്ലോറിഫൈ ചെയ്ത് പറഞ്ഞുകൊണ്ടിരുന്ന ഒരു കാര്യം എന്ന് വെച്ച് കഴിഞ്ഞാൽ നോബഡി ഹാസ് ടേൺ ഹോസ്റ്റൈൽ, ആരും ഹോസ്റ്റൈൽ ആയിട്ടില്ല, എല്ലാവരും അവരുടെ സ്റ്റാൻഡിൽ നിന്നു. പക്ഷേ ഈവൻ വെൻ എസ്പെഷ്യലി ആലഞ്ചേരി തിരുമേനിയൊക്കെ ഉദ്ദേശിച്ച കണക്ക് പറയാതെ വന്നപ്പം പോലും അവരാരും ഈ വിറ്റ്നസിനെ ഹോസ്റ്റൈലായിട്ട് ഡിക്ലെയർ ചെയ്ത് ക്രോസ് എക്സാമിൻ ചെയ്യാനുള്ള ഒരു മെത്തേഡ് നോർമൽ കേസിൽ കാണാവുന്ന ഒരു സംഗതി ഈ കേസിൽ അഡോപ്റ്റ് ചെയ്തിട്ടില്ല. ഈ രണ്ട് ഇത് എങ്ങനെയാണ് രണ്ട് സൈഡിലും, അതായത് ഫസ്റ്റ് വൺ ഈ കോടതിക്ക് 3 ഡേ 4 ഡേയും ഇങ്ങനെ സൈഡ് ലൈൻ ചെയ്യാമോ ഈ ഒരു കാര്യം പറഞ്ഞതുകൊണ്ട്? സെക്കൻഡ്, ഈ പ്രോസിക്യൂഷന്റെ ഈ വീഴ്ച ഇത് എങ്ങനെയാണ് അഫക്ട് ചെയ്തിരിക്കുന്നത്?
See, those are very important questions. On the one hand, whether P3 and P4 could have been disbelieved. If you look at the mathematical precision of the dates, yes, you could disbelieve the version of the prosecutrix or the victim, and because the dates should match when you look at that. But in the description of the incident, I think the court could have believed if the prosecution had given a suitable explanation for that. That is the job of the prosecution. Everything need not be explained and need not be precise. But the court should, whatever has happened, if you can give an explanation that inspires confidence in the court, then yes, that is possible. And second, that is also very important that some of the witnesses who were not answering as per the expectation of the prosecution, could they have been declared hostile and then asked questions in that particular manner? That should have been done. That was not done. And therefore, their explanation, their answers, which did not support the prosecution, supported the defense. That was accepted by the court. There was weakness.
Thank you, Ajit sir. Is there any other questions from the side of the participants? I believe there can be time for another
Hello, sir.
question. Abin Jacob, yes.
Sir, എൻ്റെ പേര് എബിൻ. സാർ, എനിക്ക് ചോദിക്കാനുള്ള ക്വസ്റ്റ്യൻ എന്ന് വെച്ചാൽ, ഇതിൽ വിക്ടിമും അക്യൂസ്ഡും ഒരു റിലീജിയസ് സ്ട്രക്ചറിലെ ഒരു ഹൈറാർക്കിയുടെ ഭാഗമായിട്ട് വരുന്ന 2 പേരാണ്. അപ്പം ഈ തീർച്ചയായിട്ടും ഈ ഡിസ്ക്ലോസ് ചെയ്യുന്ന കാര്യത്തിലായാലും ഒരു ഡിലേ വന്ന കാര്യത്തിലായാലും ഈ ഒരു റിലീജിയസ് ബാക്ക്ഗ്രൗണ്ട് ഒരു ഫാക്ടറായിട്ടുണ്ടായിരിക്കണം. ഇത് കോടതിയിൽ എത്രത്തോളം റെലവൻ്റ് ആണെങ്കിൽ അത് എത്രത്തോളം ഈ ജഡ്ജ്മെന്റിൽ കൺസിഡർ ചെയ്തിട്ടുണ്ട് ഈ ഒരു റിലീജിയസ് ബാക്ക്ഗ്രൗണ്ട്?
അതാണ് കോടതി ഫ്രെയിം ചെയ്ത ഫസ്റ്റ് ക്വസ്റ്റ്യൻ, അതായിരുന്നു ഫസ്റ്റ് പോയിന്റ്. Whether the accused is in a position of power and authority in relation to the victim. So after extensive discussion, the court found yes, the bishop was in a position of power and authority over the victim. And therefore, to a large extent, I think the court should have, or the prosecution should have built upon that point and said that whatever happened was the result of that. അതില് അത്രയും സക്സസ് പ്രോസിക്യൂഷൻ ഉണ്ടായിട്ടില്ല. So the first question was in favor of the prosecution. പക്ഷെ അത് കഴിഞ്ഞിട്ടുള്ളത് അത് ബിൽഡ് ചെയ്യാൻ അവർക്ക് സാധിച്ചില്ല.
Thank you, sir.
Yes, Prashant sir, I believe Prashant sir is a close associate of Project Complete Lawyer. He was trying to make a comment or question.
Yeah.
I believe.
Hi, hello Prashant. Good
How
to
are you,
see
sir?
you. I'm fine, thank you.
Long
Yes,
time.
long time.
No, so I was just trying to add on to the question asked by, I think his name was Kuriyachan. I didn't get his name very correctly, so I was just trying to add to the question that he asked.
It is Kuriyachan, yes.
മാനമര്യാദയായി ഇത് കേട്ടിട്ട് പോകാന്ന് വിചാരിച്ചതാണ്, പറഞ്ഞ എന്തെങ്കിലും കോൺട്രവേഴ്സി ആവണ്ടെന്ന് വെച്ചിട്ട്. പക്ഷേ ഐ തിങ്ക് there's a point, there's a very pertinent point that we need to discuss. I think he was not asking you if the victim's character was in question. I think what perhaps, and I may be adding some words to his question, maybe what he meant, and maybe in the general public's mind this question is there, as to whether there was a discussion, at least to the extent of there being any relationship, not otherwise the conduct, not otherwise the character, but to the extent of whether there was a relationship between the parties. Particularly, see, you don't produce the phone. Now, does it mean that if you produce the phone, certain messages will establish a certain kind of a relationship which will go against you? So it is a question in everybody's mind as to whether there was any discussion in the judgment on a potential relationship. And my answer to my limited reading of the judgment is there is nothing. The court didn't go into it, and maybe my observation is wrong because I've only read it cursorily. ഒരു പക്ഷേ ഇതില് സംഭവിച്ചിരിക്കുന്നത് ഒരു കൺസെൻഷ്വൽ റിലേഷൻഷിപ്പ് ഉണ്ടോ എന്ന ക്വസ്റ്റ്യൻ ഇതിൽ ആൻസർ ചെയ്യുന്നില്ല എന്നാണ് എൻ്റെ ആ ഏരിയയിലേക്ക് പോകുന്നില്ല എന്നാണ് എൻ്റെ ഒബ്സർവേഷൻ. കാരണം the bishop being in the position that he was possibly could not have said yes, it occurred, but it was consensual, because he's in a religious position where he cannot confess to having committed a sexual intercourse. Maybe the fact that there was a sexual intercourse in the first place itself was challenged. So the judgment didn't have to deal with the situation of there being a relationship based on consent, and the question as to whether in a fiduciary position that consent is no consent. Adana എൻ്റെ ഒരു observation. So I think in a large majority of sexual offense matters, an arguendo plea is at least taken that assuming that the incident happened, it was consensual, which I don't think in the instant case they even went into. What do you think about it?
Well, see, Prashant, we need to go by the definition of the law. Under this one, if it is without the consent and without the willingness, and in all these cases, we only have what the victim says: I did not consent, or I did not, it was against my will, then that is something that the court needs to consider and accept. If there is nothing that is against that, if there is nothing concrete, not only concrete, if there is nothing to doubt what she is saying. Now, in this one, what you asked is perhaps something that we would never know the truth about. I don't know whether I got your question correctly, but see, there are many questions in this case which is difficult to answer.
Yes.
അല്ലെ, എനിക്കൊരു സംശയം, ഈ ബിഷപ്പ് സജസ്റ്റിംഗ് ദാറ്റ് there was sexual relationship but there was no, that was consensual, അതൊരു ബുദ്ധിമുട്ടുണ്ടാക്കുന്ന ഒരു സാഹചര്യം വരുത്തില്ലേ എന്നുള്ളതാണ്.
അതാണ് ഞാൻ പറഞ്ഞത്.
അങ്ങനെ ഒരു ഡിഫൻസ്
he did not have said anything. It is for the prosecution to prove.
Yes.
He can deny the whole thing.
That's right.
And that's what they do. That is a stand they take.
Correct. So he didn't have to cross over. I mean, the stage where the factual premise is proven did not arise, and therefore he didn't have to say.
No, he didn't have to say anything. It didn't reach that stage.
Correct.
It was only the sole testimony that was being
Okay.
analyzed, and there it was found that പിന്നെ അങ്ങോട്ട് പോകേണ്ട ആവശ്യമില്ല.
പോകേണ്ട ആവശ്യമില്ല.
രണ്ട് മൂന്ന് സ്റ്റേജസും കൂടെ ഉണ്ടായിരുന്നു. It was not needed because there was no sufficient proof. So he left it there.
The other, general observation, and now since I am not in Kerala, I can say this with a slightly more holistic perspective, because I've been watching all this debate from outside Kerala. The broad aspect, and this is not coming to the nitty-gritties, but the broader aspect we need to debate about when we discuss topics like this is two contradicting principles. One is that law has its, or justice has its eyes blinded, and it is supposed to be blinded against public perception. That's one aspect. The contrasting aspect is a judgment or law or justice should not only be done but also be seen to be done. Now, between these two contradicting constraints, should the judge be swayed by media, public, or can he and therefore think that when somebody says something, possibly it is correct, and therefore from that premise I'll work backwards in trying to see if that premise, which is right at the outset established, can be made correct, or should he, or the reverse, should he think
that is the second one is a slippery slope. I think it should be the first. Should not be swayed.
Absolutely.
And
maybe so he should just open it. He should just approach it with an open mind and then see how
absolutely.
He
should go by the evidence that has been produced.
But that's where the media is now attacking.
Exactly. But we can't go by the media. Correct. The judge cannot go by the media.
So today, when the media says justice should be seen to be done, what the media essentially says is that you should only look at it from the victim's perspective, or slightly higher prerogative to the victim's perspective, and fix that, and then try and work backwards. How desirable it is or how dangerous it is a larger question.
Yes. And that's why I think the law also is reformed in such a way that we are giving now far more, or we want to believe the victim far more. And that is what the law is saying these days.
In general, I think what we can say is that the judge has done his job to the best possible way, and it is in the appellate court to look at the other perspectives that are possible, which will be laid before the High Court or the superior courts. We cannot simply say that it was not baseless judgment.
Okay, then I was closely listening to the conversation between Johnson sir, who is the chairman of the Project Complete Lawyer, and Prashant, Advocate Prashant sir, a close associate of Project Complete Lawyer. Now, we have unfortunately run out of time. It has been 1 hour 11 minutes since the session has begun. We wish to entertain all the questions. I know that there are more questions from the side of the participants, but unfortunately we have run out of time, and we have to close the session. Ajit sir, again a wonderful session given by you for us as part of Project Complete Lawyer clinical exercise. Usually the clinical exercise conducted by Project Complete Lawyer is only, it's a confidential session, only conducted for the student members of Project Complete Lawyer. But now and then we do entertain outsiders of participants who are not members of the Project Complete Lawyer to participate and explore legal problems that arise now and then that are of social legal importance. And again, I have previously mentioned Ajit sir. It's the second session of Ajit sir. Prior to this, we have taken another session on the criminal jurisdiction of High Court, and again a difficult topic taken by him. a controversial subject, nevertheless, especially in the Kerala society, within the state of Kerala. A difficult subject, nevertheless. He was trying to discuss with all of you his bona fide, objective, unbiased analysis of the judgment, for all the benefit of the participants. And he has done justice to the presentation, and he has delivered, even though a difficult job, he has delivered the task in the due time. Thank you, sir, for your valuable time and for your valuable analysis, which is definitely based on your extensive experience as a criminal lawyer in the High Court of Kerala. And I believe that it has provoked many questions from the side of the participants. And all the answers given by you are definitely satisfactory. And I'm very sure that there are more questions. If you have any other questions that you would like to answer, get a response from AJITH sir, he will try to answer them to the best of his ability. And the questions can be raised through email. Kindly raise your questions and send them to completelawyer2021@gmail.com. And after collecting all the questions, we will post it to AJITH sir. He will be trying his best to answer all of them. So thank you, AJITH sir. On behalf of Law and Justice Research Foundation and the Cochin Institute of International Arbitration, I would like to thank you for your contribution as the convener of Project Complete Lawyer. Thank you, sir.
Thank you, Ajit. Thank you.
Thank you, everyone. Gentle reminder,
Thank you, sir.
there will be a secondary section conducted by C. Ananda and Vismaya Shaji, who are volunteers of Law and Justice Research Foundation voice.com, LJRFvoice.com, which is a academic online digital platform where we publish articles written by academicians and law students on social legal subject matters. They will also be making a presentation of the Bishop case, expressing on their point of view. So they will be trying to add to what AJITH sir has presented, and they will be expressing their own point of views as part of the clinical exercise of Project Complete Lawyer. Yes, Prashant sir. Yes. Yes,
When you deal with, I hope only our people are there. Topics handle we should very clearly say it is an academic exercise. Close to 90 people were there. I'm just hoping that nobody at the end of the day says we conducted a program where we very, insensitively said this is what it is, and now you go to the higher court. And that is what a bunch of lawyers said. No, I'm serious. Other academic exercise so that media doesn't catch it and nobody thinks we are a bunch of insensitive people. We're just presenting one side of what the speaker thought, and it's not even any one of our view. One speaker, anybody is free to speak based on his understanding. Somebody else may come and speak something totally differently. In fact, there are a lot of people speaking with a lot of conviction as to why this judgment is wrong. A lot of people. So, and in a legally sound way, including I saw some of the Supreme Court senior counsel. I think Vrinda Grover was finding it wrong, and so many other people. So we should be very sensitive in always making the audience very clear about our intentions in the matters, what my very humble request is.
Yes, sir. It's noted. We will do that definitely.
Your sir, Advocate Ajit sir has presented a bona fide, unbiased and objective analysis, and this is a disclaimer. All the analysis made by him is an analysis from his personal perspective and experience as a criminal lawyer from the High Court, and this is not an attempt to discredit the judgment of the concerned judiciary. And all the opinion expressed by him are a personal opinion, and this is a clear exercise of freedom of expression, freedom of opinion, expression of opinion, and within the limits of reasonable restrictions. So thank you, sir, Prashant sir, for that clarification. And again, I would like to emphasize the same. Thank you all the participants for your valuable time and patient listening, and hope to see you all again in our second session. Thank you.